Thank you everyone for joining. We'll give everyone a few minutes as everyone starts to file into the virtual Zoom room here. While you're waiting, you should see a poll question on your screen if you'd like to go ahead and submit an answer, and we'll begin momentarily. All right, looks like there's still quite a few people coming in, so we'll give it a few more minutes and then we'll get started. All right, just a few more seconds, and if some of you still haven't submitted a answer to the poll question, please go ahead and do that, and we'll share the results here in a moment, and we'll get started in just a second. Okay, great. I think everyone has made their way into the room. Thank you all who also submitted an answer to the poll question. We'll go ahead and share those results here in a moment. There we go. So thank you for joining us for the final keynote and closing remarks for the Spokes Privacy Technology Conference. I'm excited to introduce your presenter for today's final session, Justin Antoni-Pillay, founder and CEO of WireWheel. Justin, I'll pass it off to you.
Mark, thanks so much. And again, thanks to everybody who's joining us today. We have a terrific keynote who I'm about to introduce as our closing session. But before I do, it takes a lot to put on a conference like this, and certainly that is true in this time of COVID. And so I want to spend a moment just to thank some key members of our team and others who have really done a tremendous amount of work to make Spokes, our fall conference, winter conference, such an outstanding session. I want to start by thanking Ali Hupel, Kemi Landau, Erlich Alba, Judy Gordon, Emma Goncheva, Emily Sackett, and Pierre Boudet, our crackerjack marketing team, who've just done an outstanding job putting this together. And of course, our hosts during these sessions today, Sarah Van Pelt and Mark LaFleur. Our team has had a tremendous amount of support from our customer support and success team, including Brandon Lucchino, who actually came back from vacation to help today. I don't want to leave anybody out. It's been a whole team effort. I hope everybody who's attended Spokes can see how much work went into this, and I'm really proud of all that everybody's done. So thank you all very much. There are also, of course, a lot of other folks, all of our speakers who donated their time to come and share their insights. Yeah, I want to highlight Bruno Gencarelli, for example, excusing himself from the Brexit discussions to be here today, but also at every single panel, folks who are just contributing time to share their insights with our community. Dan Solov and Jules Polonetsky have done so much to support what we've been doing here at Spokes. So thank you all very much. I hope you've enjoyed all of our sessions here today. This is part of our mission at WireWheel, to democratize this critical information around privacy, privacy technology, national security policy, make it available to the community, make it available to you, and I really hope you've enjoyed it. With that, we're to our closing keynote, and I'd like to welcome Alastair Mactaggart, the board chair and founder of Californians for Consumer Privacy. Alastair has been the driving force behind two of the more significant laws in privacy to pass in the United States, the CCPA and the CPRA, which just passed here a few weeks ago. Alastair's been a friend and a participant in our sessions before, but there are a lot of questions and a lot of points that we're delighted to talk to you about today. So with that, welcome Alastair Mactaggart to Spokes today. Alastair, can you hear me okay?
I sure can.
Great, welcome. Welcome and thanks for joining. It's good to see you again. When I spoke to you last, it was before all of the final votes around CPRA, and obviously there was a lot going on in terms of, groups arguing for or against it. But congrats, you got it passed. It's a heck of an achievement. You got to be proud.
I mean, I'm really grateful. It was sort of my first time through something like this, and I was certainly nervous, but ended up with a 2 million vote margin. So, in an era of tens of thousands of votes around the country, determining bigger elections, this one felt really good.
Yeah, and I mean, you've now spent. I mean, Alastair, just so that folks hear it, before a couple of years ago, I don't know, had you done a lot in the political advocacy space? And now you've spent probably a good chunk of your time for the last 2-3 years, right?
It is. I sometimes it's more improbable to me probably than to anybody else, because I certainly never expected to be here and had no intention of being here. But yeah, it's the last 5 years has been a journey, because even though CCPA passed in 2018, it took about 3 years of my time to get there. And then obviously the last 2 years since. So it's been a short, relatively, but a very intense period of my life.
And before we get into, now there's going to be a lot of follow-up to CPRA. There's a big process that's going to follow. But before we get there, have you picked your next issue? Are you going to have the California version of platform immunity? Are you looking at some kind of trade deal with different parts? Have you figured out what your next thing is? Are you running for governor?
No, I mean, I think privacy. I feel good with where it is right now. One of the interesting parts of this, though, has been, not to be facetious, you look at other areas that are sort of intractable, and my conviction always was, if you could make a case to the people that was relatively simple, people would vote for it. And I think, our state is so screwed up around housing. I bet you there's something, if people took the time to look into the housing problem in California, you could probably solve it, a portion of it.
All right, housing's next. All right, so let's turn to a couple of things that I think in terms of next phases, but also some bigger picture issues. CCPA was a starting point. CPRA is the next version of it. But in the next year, there's, the law has passed, but there's a fair amount to come. For folks who are joining in and just trying to understand it, do you mind walking through what comes next? What are the big milestones, and what do folks really need to know?
All right, well, the election, gets certified, and I actually should know the date, but in the next week or two, by the Secretary of State here. Then that actually the law goes into effect at that point. Then within, I think, 90 days, the commission is named, and that's the governor, the AG, the pro tem, the Senate, and the speaker. And then, there's a process where they give notice that they're ready to make rulemaking authority. But around the middle of next year, they take over rulemaking authority under the act. And enforcement, the new rules go into effect or are published in the middle of the following year, 2022. And then they're not enforced until 2023, the middle of 2023. They go into effect in January 2023, and they're not enforced until July 1st, 2023. So there's a lead-in process to give time. One of the things that was interesting is that it took a little more time than I had expected for the CCPA regs to get finalized. So we left ample time here for this to happen again.
Yeah, and one of the big things is over the next year, you really will see kind of much more of an internal accountability process. The assessments, the audits, all of that infrastructure coming into pass. Do you have any insights about where that's going, or you just expect that'll be turned over to a rulemaking body that will figure that out?
Well, the agency becomes the rulemaking, or the commission hires I presume, because they have to write bylaws, but I presume they hire the director and or a couple of, like, the chief technical officer or someone like that, and then they publish the rules. So all that will be subject to eventual final rules. What one way to think about this is the CPRA just really, one of its aspects is it creates an agency and gives it very broad rulemaking authority. And Section 185 has a long list of things it needs to do, but also says, and it can do other things over time. I think if you look at the FTC, that's probably the lesson that's important, is you need to have rulemaking authority, which the AG currently has, but that'll just get transferred over to the agency.
I assume you had other things to do, but when you're hosting a conference like this, and over the last couple of days, thousands of people are coming and talking about what it means and what it's changed and how it's affected their company. If you could step back for a minute, and I know we often get into the weeds of like this requirement and that requirement. One point that came up in a couple of different panels is, we know this is not going to happen overnight. And that just by passing a law, it doesn't really change everything immediately. There's sort of a motion to these things. And Bruno Gencarelli from the European Commission, who I know you've met and spoken with before, he had the same point, in the sense that there's sort of a bend to this action, that over several years you start moving it. In these first couple of years, for just the people of California, they start to see little incremental changes. They might see a do not sell button. They might see an ability to get their data. You're going to see more changes over it. I think when you're running a technology company like ours who's focused on this, you start thinking about the human experience, the user experience, and you want to make that amazing over time. But what ultimately where do you see this going, right? If you imagine a couple of years from now and this has been implemented, what will this really change for consumers, big picture? Forget about the little interactions or what companies have to do. Between the two laws that you've invested so much, what are you trying to change, and what do you want it to look like a few years from now for the people of California who get to benefit from this?
Well, I think in the stepping back, if I take that to heart, the reality is, this is I believe that legislation is a living, is best when it's living and changes over time. The construct of CPRA is that the legislature can and will change it with a simple majority, as long as it doesn't harm consumer privacy. I think really I don't think we had very good consumer privacy before all this started. I think now with CPRA, we essentially, I think, have rough equivalents with GDPR. I think that will drive a change in this country. I guess I look at it as, I don't think there's going to be and now here's the resting place, right? This is going to evolve over time as technology changes, as expectations from society change. And I keep on using this one example of antitrust, how the world would look if we hadn't had, you're the lawyer, tell me, it was Sherman Clayton was the first one, when it was, 1900 or somewhere around then. But if we hadn't had antitrust, but still today, we're still debating where the edge of antitrust should be and what's appropriate. I think 130 years from now, the same thing will be happening with privacy. I think the more alarming thing is if there weren't any of these, any good privacy law, at some point, I do think the industry becomes too powerful to regulate. So I'm gratified that in my mind, this is sort of one of those areas where we shut the barn door before the horse had left. And in terms of your specific question about California consumers, I've never believed that every consumer is going to spend a lot of time on every site making sure that their information isn't being sold. So over time, I think this needs to get to a place where I, as a consumer, can do one thing, right? I can set it and forget it. I can make sure my browser is set to maximum privacy. I can make sure my phone is set to maximum privacy, or install an app. I think there's going to be business-facing companies that are going to explode because of the demand for privacy on the business side, and there are going to be consumer-facing companies that are going to also cater to my desire for privacy. And these agents, one of the constructs that I like most about both CCPA and CPRA is we ensure that another person can act for you, that can intervene for you, because it's too complicated if you have to do this all yourself. And so I think over time that'll get easier and easier, where you have these tools that you can use. Much the same way, think about antivirus software, right? Like none of us is really an antivirus engineer, but we know we should have this somewhere in our system, otherwise bad things happen.
And what that makes, honestly, on that part of it, on the do not sell and trying to effectuate it, especially even trying to understand as just a person that walks the earth, what is going on with real-time advertising, I think is almost impossible right now. It just takes years, even for folks in the field, to do that. So trying to understand how you would do that on a one-on-one basis and effectuate it is a bridge too far.
Right.
But even on the right to knowledge, do you have a vision? Again, it's not going to happen overnight, but do you have a vision of what you would imagine it's going to look like over the next couple of years in terms of just even understanding what is happening with your data, where is it being shared, and almost like a nutrition label for your data?
Sure.
Because
that's an interesting question. Let me come back to that, the nutrition label. Look, I've never believed that you have an access right and all of a sudden means millions of consumers are going to say, hey, what happened to my data? But I've never believed that was really important. What's important is that the people who care, the journalists, the technologists, now have this tool. And it's much like the Freedom of Information Act. I mean, how many people in a given room have ever used it? None, right? But isn't it really important that the Julie Angwins of the world, can actually access what the government's doing so they can find out about this, and then they can publicize that. And then with the sunlight, you get the disinfection of the activities that are sort of not great. And what I keep on saying to businesses is, look, if you're doing stuff with people's data that if they found out about, they'd be totally fine with, then you have nothing to worry about. But if your business model is doing stuff with people's data, where if they found out about, they'd recoil and be like, what? You're doing that? Then I think you should adjust your business model, because I don't think that, and it's the same thing exactly coming back to the food labeling, which I think is a great idea. And I hope that movement takes off. I may decide to eat the stuff with a ton of saturated fat right now because I feel like it, but at least I know I'm doing it, right? It's a good thing to have. It doesn't mean you won't do it. But if there were no labels, it's just not a great idea for consumers. So.
No, yeah, I get it. And that makes, again, sense. And I think there will have to be an evolution of exactly what is the most meaningful information. And I've mentioned this to you. In my view, I've been surprised about just how many requests there are. There are companies getting thousands of them, right, to see and get a sense of your data. I do think the ability to deal with opting out of the sale of your data or opting out of certain behavioral advertising is probably going to be used more. There's a sense for some folks, you probably have heard it too. It probably was one of the things driving you, where you do a search or you go to a website and suddenly you start seeing that everywhere. And some folks it doesn't bother, but some folks find it very, very creepy. And I think there's some line in there that is going to have to really move.
Right.
Now, a lot of the panels that we have been dealing with, obviously nationally, you have a new federal, a new administration coming in. It's a big deal. It's a transition between, one to the Biden administration. And that's brought back a lot of the discussion points around perhaps federal legislation versus the advancing state of state legislation. So, for example, Julie Brill was on an earlier panel from Microsoft, and there's a lot of momentum, I think, again, behind Washington passing its own version of a law, although that it's started and stopped a couple of different times. So, having gone through it now from the state process through the ballot initiative, do you have a view about where you think it's more likely to move in the next year or two? Or is it your sense that we're moving through more states, or do you have a sense about whether CCPA and CPRA make, for example, a federal law, more likely or less likely?
Well, let me say, as an American, I would welcome a strong federal law that protected Americans everywhere. I think the question now federally is, it becomes more interesting, and kind of one of, frankly, the reasons I was eager to do this in California is because of California's place in the union. So if you think about the fact that I checked the other day, and I think, I don't know if it's the current data, but I think it's 46 Democratic representatives from California. So that's just over like 21% of the House Democratic caucus. And I counted them up, and I think there are 4 committee chairs. We got the speaker, the minority leader, 22 subcommittee chairs. It's a powerful congressional delegation, the most powerful. So if 9.5 million people has just voted for this law in your state, I guess my question to them would be, are you going to now roll over and say, hey, federal government, sure, go ahead and preempt our law? I don't think so. I think that's probably not especially when the law that the people just voted for in California is specifically designed to change with time, right? It was not at all said, okay, it's a point in time, it's perfect. It's like, no, this is a minimum floor and it can grow over time. I think if you think about trying to get something done in Congress that is as tough as California or as effective as California, you got to think about the private right of action around negligent data breach, and wonder how likely is it that if it's a Republican Senate that they would agree to that. And then if they don't have a private right of action around the negligent data breach, is it as effective as we are? Think about enforcement, right? So now enforcement, we have the agency fully funded. We have the Attorney General that can take over an action. And because of the unfair competition law in California, now all 58 county district attorneys and the 4 biggest city attorneys, and by the way, LA is, I think, the 10th largest state if it were a state, right? These are big departments. They all can enforce the law as well. So again, if you had a federal law that just said, okay, well, the Attorney General of every state can enforce, that's clearly not as strong as California. And so I look at HIPAA, I look at GLBA. Both of those are floors, not ceilings. So the precedent has already been set for national privacy legislation that is a floor. And I think the common sense question to any California legislator would be, great, let's have good privacy law in the country, but why should it preempt California when the model is already there for laws that don't? And I don't frankly buy the industry kind of lament, like, oh, we can't possibly live with 50 different laws, because they do it in licensing, they do it in opening hours, they do it in sales tax, they do it in, look at health and there are banks and hospitals in all 50 states, right? And many states have their own version of the HIPAA, or we in California, we have our own version of medical and financial services privacy laws that are stricter than the federal ones. So I tend to think that if there is a federal law, at least the Californians will be arguing hard for it not to preempt. And I think we already have like the data breach model where California passed the law, Congress didn't act, and eventually all 50 states have their own version of data breach. And I don't think that's nuclear for business. And I think especially if we do get adequacy here in California, there's going to be even more reason to say, look, let's follow that model and do it more quickly than as a state can do, because we all know it's going to take a minute for Congress to agree on what day it is.
Well, so we'll have to come back to adequacy. That'll definitely be something I want to talk about. And it was something that we mentioned with Bruno earlier. But let me ask you this, you come from a business background too. If there is a federal law and it's essentially capturing the basic requirements that you've got between the baselines and CCPA and CPRA, and it does preempt, I assume would that offend you? In other words, do you
only in this way, Justin? I think we all know in this, I assume, you're a bunch of privacy experts here. Just look at ECPA, right? 1986 law. And it's the law of the land today. Actually, you're the one who told me. I know a couple of years ago, and I had to go look it up because it was so unbelievable, that it's the law of the land today that your stored electronic communications and mine that are over 180 days old are accessible by law enforcement without a warrant. And this is this is crazy. This is 34 years old. And it's passed unanimously out of the House of Representatives twice, something to change it. And both times it gets hung up in the Senate. So my point here would be, if Congress were nimble and always sort of did the rational thing, then I probably wouldn't obviously have any problem. But the worry is that you have a national privacy legislation that preempts and then it just sits there for 35 years and doesn't change. Whereas my entire approach with this new initiative has been to say to the California legislature, no, you guys keep on legislating because that's your job, but we're just going to establish a floor for privacy. And so since we didn't take the position here that we should have one law because we're so smart, we know what the future holds, I don't think Congress should either.
That's interesting. And it's interesting to see the perspective, Alastair. I get it. Look, and by the way, ECPA, I still think, first of all, that's an acronym I hadn't heard of before like 6 years ago. I still think it's one of the craziest things legally out there. It's the Electronic Communications Privacy Act, which has this provision based on 1980s technology that, because at the time, service providers couldn't store very much information, and some of those service providers were email providers. The idea was that if you leave your email on one of the major providers for longer than 180 days, it was the functional equivalent of kind of a business transaction, like you didn't care about the privacy of the data, and therefore, civil agencies and government agencies could access it without getting a warrant. That was the concept. And it really hasn't changed, even though I think, I would bet you 99% of human beings do not view emails that sit on any one of the major service providers for more than 180 days as non-public. I think most people view that as private. To their credit, most of the major providers of email have fought this. So there's a fundamental, sort of litigation going on around this. I have also, and this is a consistent view that you hear, I think there are three major barriers to national privacy legislation. Three, probably more, but one is preemption. And I do think in the absence of preemption, it becomes very hard to get something done. I'm not saying that your position's not right, but that's usually one of the main reasons that goes behind this, that you would have a single national standard. The second is usually private right of action. And you and I have talked about that, but it's probably worth talking about that in a minute too, like the scope you have, because it becomes a point of debate. And it probably was one of the main reasons you had any opposition to CPRA from what one would normally call civil society kind of groups, right, in the last round. The third major impediment I see actually to major national, privacy legislation is that when you get into this from the perspective of this is really inside baseball. And by the way, I can see in the attendees a lot of my former colleagues here who I think are probably nodding. But when you start to develop a national privacy law, it goes through an interagency process. And two of the groups that end up weighing in heavily are civil, enforcement groups, national security, and law enforcement. And right now, the amount of data that is held by third-party platforms is an enormous resource for most national security, law enforcement or civil enforcement purposes. It's just a place they can go to gather data. I'm not saying inappropriately, but pursuant to a warrant or a civil subpoena or something else. And there's a pretty strong force against limiting collection or limiting retention in those agencies. And that's going to be a big voice in terms of national privacy legislation. And that voice isn't the same in states, right? So in California, when you're going through the legislative process, I doubt that you have national security agencies coming in to explain that. And that is in fact a different, sort of a different issue. But anyway, I do think preemption, private right of action, and and the sort of civil enforcement or legal enforcement still is a huge bar to getting it done. But anyway, I'll let you react to that. But then the two subjects I'd probably talk about here are both adequacy and private right of action. So do you mind if I don't know if you want to respond to anything I said, or if we should go on?
No, I mean, look, I agree. I think honestly, one of the reasons it felt like the right thing to do with the initiative here is precisely to make it difficult for a federal privacy law to get passed. I think this makes it much more difficult for something that, looks like it's doing something that actually doesn't do anything to get passed. Because I think, Congress does need to have its feet held to the fire in terms of, hey, look, if you're going to do something, it better be darn good,
Well, before I go on, this spokes does give folks a chance to actually ask questions directly. So anybody who's watching or listening, please post to the Q&A, and Alastair and I will pull from those here in the next few minutes. Okay, now adequacy. So there was a decision, as you know, in Europe, Schrems II, that invalidated Privacy Shield, something I worked on years ago. But both the European Commission and the US government, in fact, we had both representatives here at Spokes reaffirm that they're engaging in terms of trying to get a new Privacy Shield in place that would be adequate. And obviously that must mean that they're working on frameworks that address this national security holding in Schrems, which would be enormously beneficial if that can be done, because there were very few complaints really about misconduct under Privacy Shield. And Privacy Shield enabled a lot of companies, small growing companies, to commit to do more to protect human privacy, and they get the benefit of moving data around. With a new Privacy Shield, if they get it done, that means there's the ability to move data from Europe to the United States. And guess what? That gives you an opening with CCPA and CPRA to think about California as an adequate state itself. Have you thought about that? And is that on your radar, or is that one of those things you're going to leave to the side for now?
No, it's absolutely, if not the driving force, one of the driving forces for doing the initiative this time around was to make sure that in CPRA, there is nothing either missing that the Europeans would say, well, because you're missing that, there's no way to get adequacy, or also nothing included that, again, the Europeans would say, well, because that's in there, you can't get adequacy. So I feel pretty good that the ability is there. It's, as you know, a political decision of the commission, but it's not a treaty that a state has to enter into, which would be a problem. It's a one-way certification. It's right there in GDPR that they can deem a territory of a country adequate. So I think it's a next natural thing, and I think it'd be great for people, Californians, because I think if you have this external kind of imprimatur, it's one more reason why privacy won't get weak in California. I also think it'd be great for California business, because, or if you're going to put a data center somewhere, you're going to put it in the adequate state so you can process data from around the world. So I think it's kind of a no-brainer for California to apply, and I hope they will. Honestly, I think it's really an overt way, and I credit you for the one you were the one who brought it up with me more than a year ago to start thinking about this, and so that really did sort of trigger me to start thinking, I wonder what the next step here is.
Well, I think it would be phenomenal, right? If in fact companies are doing all of this and have a clear, easy, direct means of transfer that is deemed adequate independently, that's huge. And you have less of a variation based on, individual findings. It just creates a much more efficient basis for it. So good luck with it. And do you expect to play some role in trying to get that done?
I mean, if it's hopping on the phone with folks, or who knows what, but trying to gather up support, or evangelize, sure, yes, because I think it really would be great for. It's one of those rare kind of free lunches. I think it'd be good for everybody. It'd be good for the consumers. It'd be good for California. Good for our business. So I think I'd really, and I think it would be good because it would give an incentive to other states to really act maybe more quickly than they would. If we got adequacy, I think in my mind, I've always thought that that privacy could be an analog to the clean air. California Air Resources Board essentially sets the standards for the country. And now that we have a different change of administration, they will, I think, let California do this again, because for decades we had the strictest regulations, and I think 12 states follow us, and so the automakers are like, we're not going to make two sets of cars here, so we're just going to go with the strictest standard.
Got it. Well, I think it's exciting.
By the way, we already saw that with CCPA. I've always believed that it's going to be hard for consumer-facing companies to say, your sister in California has these rights, but you in Texas or Kansas don't. And so we saw it with Microsoft. They were, I think, the first big company to say, we're going to extend CCPA rights to the entire country. Apple did it. I think companies that get it are just think it's untenable to give protections to 1 in 8 Americans and not to the other 7.
I get it. Well, let's, we have a couple of really interesting questions I'm going to pose that came in from our viewers. So here's the first one. Do you have any insight into how many consumer complaints they've been with the AG under CCPA? And are you aware of those? I mean, I've seen, for example, on my side, Alastair, the issuance of quite a few violation notices by the Attorney General's office, and they obviously have been quite aggressive, I think, in going out and looking for violations. But do you know if there have been complaints or consumer complaints?
I will tell you, it's been the fog of war the last couple of months. So I've just been head down and trying to get this thing passed. And so I haven't spent a lot of time monitoring CCPA as much as I should have. And so I really haven't followed that. No,
I got it. Okay, here's a second one. This is an interesting one. What do you think of the argument that new privacy laws give big tech platforms a defense to antitrust actions? I think the idea here is companies like Apple are building more privacy obligations into their platforms, Google as well, in order to make it harder for their competitors to collect data. And that the defense is, well, we're having to do that as a result of a privacy law. Have you thought about that side of it? Obviously, the compliance, you and I have talked about this generally, but there is this notion, and I think it's a fair point, that the more regulation, it creates a barrier to entry to smaller companies. Obviously, that's something Wirewheel is trying to tackle, but in the meantime, you have companies that are huge that are able to, it's not a big deal to go tackle the next privacy regulation, whereas smaller companies have to, sort of spend much more of their overall funding to get there. So any thoughts on that in terms of small, medium-sized companies or antitrust implications?
Yes. I mean, I think it's not even as much the antitrust, it's just the barrier to entry, and the fact that, a criticism that has been, expressed for some time is that regulation will hurt small companies more than big companies. And so therefore I'm really acting as a shill for large enterprises. And I think my answer is, look, there's no perfect answer here. If you're going to have regulation, any field, clearly a company that has more resources will be able to meet that regulation sooner. Though that said, if you're a new company, I disagree, because the new company just sets itself up from day one. So I think it doesn't hurt innovation in that sense. And what I would answer also is, look, we just, I think, created a privacy industry here in California. I mean, obviously companies like yours were already in existence, but by giving a legal sort of mandate to businesses to deal with that third party, that agent of mine, we've just legitimized in statute the existence of companies that can act for me. And I'm convinced that there will be a wellspring of these companies that will come there to help me manage my privacy. And I mean, I've had literally dozens of conversations this year with companies that are doing that, and that's just CCPA. Now with CPRA, even more kind of rights that a consumer has. So I think, again, go back to the antivirus with the security industry that really didn't exist. Then you had the viruses, and then all of a sudden you have this now massive industry that has sprung up to help manage my security. I think the same thing will happen with privacy, and I come back to, like, I would rather have the rights as a human being. So if the big hospital that's a little more expensive has a clean operating room, and it's, you know, better able to deal with the health regulations than some, like, back of a, you know, person's shack, then I actually would go to the big hospital. You know, I as a person want the rights, and I want the protections, and there's no free lunch. So
I get it. And, well, do you mind if I then take us to one or two specific items, and then we're as I guess we're going to run out of time, Alastair. But here's a one. From a technology perspective, one of the things we actually help companies with is this interesting challenge of retargeting and targeted advertising. For example, we had a phenomenal brand, and they had a core mission that if somebody, you know, it was important to them that if somebody said, do not sell my data, retargeting stopped, and they could do it for everybody else because it was fair, right? Notice, and people are comfortable with that. And there is some technical implementation you have to do at this point to make that happen, to make sure that somebody can opt out and then have the retargeting stop. And that's a thing we do. But there is a pretty big debate, and I watched a couple of them today. You might find it interesting at some point just to see how experts are debating this. Did CCPA prohibit, or what was the limit to what it prohibited in terms of targeted and retargeted advertising? And then, of course, in CPRA, there's a concept of cross-context or cross-contextual behavioral advertising. It doesn't use the word retargeting. So even if we just set aside the question about what's covered under CPRA, I'm sorry, CCPA, if we focus just on the new CPRA, in this concept of cross-context behavioral advertising, I'll just give you a simple scenario. Justin goes to a website. On that website, let's say it's a direct-to-consumer brand. I want to buy an outdoor, an outdoor fire pit, for example. Okay, so I go look at an outdoor fire pit site, and then I go to 4 other sites and some of my social media platforms, and I start seeing ads for that fire pit. If I've made the choice to opt out of the sale of data or opt out of this new version of cross-contextual behavioral advertising, under CPRA, are the ads I'm seeing on other sites and on social media permitted or not permitted?
Not permitted. So the answer is CCPA has a problem in the definition of service provider, frankly. And so if you write the contract correctly, you can do this. And that's one of the reasons, another one of the many reasons why I really was focused on doing this new initiative was, long story of why service providers there. It wasn't in the original ballot language. It kind of came in the last minute, and I caught most of the things that were kind of negotiated in the last minute, but that was one I did not catch. And so what CPRA does is it makes it very, very clear that if I'm on a site and I say, don't sell my information, I do not sell, don't share my information, I have that enabled, that site cannot share that information for advertising somewhere else. And that so that it really is my interaction with that site stays in the silo of that site. And if that site has like Google Analytics enabled, well, Google can know about what I'm doing on that site, but it can only use it with respect to that site. It can't use it, can't combine it with information it's learned about me from my own searches, or it's learned about me from my activities on another site. And that's one of the fundamentally, I think, important parts of CPRA.
And there's nuance to this, which I think we could probably spend all night on, but I won't go much deeper. So, but sometimes these cross-platform ads are not served by taking Justin's direct information and passing it to the platform. They're actually served by defining a segment that's very specific on the other platform and serving some non-direct identifier about Justin to that platform, right? So it gets to a degree of separation that's not the same as having just taken my, say Justin's information and passing it onto the platforms. I suspect a lot of this will end up being sussed out in rulemaking and other things that follow. But have you thought about those kinds of examples?
Well, I mean, sure. If you can go to Facebook and say, I want to know, middle-aged real estate developers who've got a passion for privacy and they live in Piedmont, they got a couple of kids, 3 kids. I mean, if if the advertiser knew enough about that and didn't know my name, and went to Facebook, I mean, clearly they could target me. At some point, that's where it gets a little suspect. Like, well, how did they know all that information? So I think the business of Facebook knowing a lot about its customers and being able to market to them is not going to go away, but the business of me being able to track me across a whole bunch of websites and have Facebook know what I'm doing on all those different websites when I don't want them to know what I'm doing on all those different websites, I think that goes away. And that is clearly one of the goals here, is to give you power to who you're doing business with because you're intentionally interacting with that website. But what you don't expect is that interaction will be shared and used and monetized by other businesses that you've never heard of.
Alastair, we're to the last few minutes. I want to, well, first of all, look, I think most of us who've been working this field for a long time, and it comes up regularly, you have to really respect what you've done to get something like this through. I hope you're proud. I know there's a lot to be sussed at, right? There's going to be a lot of views on this, right? One way or another. But it's rare that one gets a chance to make a difference on something this big and start a movement like this. And so, congratulations for having made it through all of these different gauntlets in these last few years. I know we'll have a lot more to talk about. I hope you'll join us again. And I can tell you on behalf of folks who can what we do at Spokes in these communities is try to make this information free and available to the community. And we actually have law students. We have all kinds of folks who watch this and can learn from it. And the goal is we don't want this information around what you have to do to be kept in a small group. We want it to be available. So we appreciate you taking the time to come and talk about this. I actually would have been interested to hear what you had to say about some of this platform immunity sort of issues. It's all over the paper today on what's called Section 230. I'm sure you and I could talk about, some of the election, how some of the platforms serve different information in response to results. You and I have talked about any of these things, but what I would do is just, if you have a few minutes and there's something you'd like to sort of cover in these last few minutes before we wrap up, we'd love to hear it. What are some of the things we should be thinking about on these subjects?
Well, I'll just address what you just talked about because it's top of mind. I mean, the first thing I'd say is, I think I got lucky. These things, sometimes you're the right person at the right time. And, if at the wrong time, this could have been impossible. This happened to be the right time. I had a tremendous amount of help from people like you along the way, who were willing to talk to someone who, initially knew nothing about this area. So I feel mostly fortunate. And I feel good about the future because I think, now we go back to the legislature to legislate. I think around the platforms, I tried to organize my thoughts around things that we could do as a state. So obviously that's a federal situation, Section 230. The one thing I would say is, to the extent that the internet has been destructive to the free press, and to the extent that that has been destructive to democracy, because I think now that truth is this wishy-washy thing that we can all define, there's no sort of sense of this is actually true. And I think the loss of respected voices has really contributed to that. I think it's unfair to think, okay, I'm going to take the news business, the traditional news media, and I'm going to hold them to this very high standard of liability, where they can't publish stuff that's, knowingly false. And then on this other platform, I'm going to say, go ahead. And that's one thing when that platform is just a platform. But when they start to curate, the thing I've read, and this is not my idea, this is, lots of other people have said this, but when that platform starts to curate my news, it starts to show my news and really acts as an editor, there's a real blurring there of, okay, well, now you're really actually acting as a newspaper. So why are you not liable? And why is this other, the old media liable? And so I hope that gets resolved. I do think, as I said earlier, I think CPRA really will help the news media because if you're a content generator, if you're the New York Times, the Washington Post, or something like that, and you want to reach that consumer. I mean, right now what happens is the platforms can watch you on those sites, take all that interaction, and then use it and advertise on their own sites. That dynamic changes. So now if you want to reach that New York Times consumer and because of what they did on the New York Times site, you're going to have to advertise in the New York Times. And I think that's one of the real benefits of CPRA is that we help make those sites more viable. We're going to help the news business. And then around elections, I just think, look, I'm not anti-business. I'm really not. I'm a capitalist. But I don't know if you followed what happened to us, which I think was a Google error. But what ended up happening in the last closing days of the election is that the Secretary of State's voter information guide is always one of the top 2 or 3 results returned in a search for Prop 24 or Prop 22. And the Google snippet showed for Prop 24 in the last week, it says Prop 24, and then it showed an excerpt from the opposition argument. Like, this is terrible, this is going to destroy privacy. And that's the thing that shows up in your first search. So we contacted them and they're like, oh no, this is the Secretary of State's problem. So just pause for 1 second. I actually, and I'll just tell this to anybody at Google, it to me is unbelievably arrogant in a democracy that you who are essentially the arbiter of truth, tell the Secretary of State, an official government body that's publishing an official government document, that they have to configure their site some way so that your crawler identifies the right portion of their site. That's crazy. The Secretary of State doesn't have a duty to do that. Their duty is to publish the darn thing on the internet. And now so what happened is we objected. Finally, the Secretary of State did change. They bowed to Google and changed their site. And then it showed up again, only now when you search for all the propositions 12 through 25, 14 through 25. For everybody else, it was blank, but for us, it still showed the negative opposition argument under the voter information guide, that link. I don't think there was I'm not a conspiracy theorist. I don't think there was some crazy person at Google who was like, we really want to stop this. But here's the point. How do I know? If one of these sites wanted to change the election by using its resources to change the information I see, it actually is their First Amendment right, and there's no disclosure required. That's actually, in a democracy, that's crazy. So I think that, there's some areas that we can strengthen. I hope to address that next year. You can't stop it because it's a First Amendment right of a corporation to do this, but it could be disclosable. Sorry, that was a long answer.
No, but it was a good one. And I'm looking forward to picking this conversation up with you, Alastair. As I said, I really do appreciate you taking the time. I know you were in the middle of a lot of things today to come and speak to our community here. And
I wasn't doing Brexit negotiations.
Very few people are. But listen, I really do appreciate your time. Thank you for coming to speak to us today. You are in fact our closing keynote. So I will close by saying just the following. We here on the team and our entire team, we're really proud to put this on. As I mentioned when I opened, I'm tremendously proud of what our team has put together for everybody who was able to attend. And we're really looking forward to continuing this for folks in the new year. And it's been quite a year for so many of us, I know, and I feel lucky. I hope for those of you that have had a harder year, that it gets better. And, I think all of us are seeing a lot of hope coming with the vaccines starting to be distributed around the world and hopefully getting approved and distributed here soon. I can say, I'm looking forward to seeing you, Alastair, in person. I'm looking forward to see our whole community in person. And our team's looking forward to actually having a spokes where we can have the community building, the sort of ability to collaborate, and more importantly, the ability to see people. And there are a lot of folks I can see even attending the session that I normally would have a coffee, have a drink, have a hug, and it's been way too long since we've all seen each other. So I'm going to close Spokes as we opened by just saying thank you for everybody who came. Thank you to our team who pulled off such an amazing conference today. Thank you to the speakers who volunteered their time to come and share their insights with us. And more than anything, be safe in the holiday season. Let's all get through these last few months, hopefully, of this pandemic safely. And let's bring our community together, hopefully at Spokes and at other places soon, where we can actually share some time together. And with that, our Spokes is over for today. Alastair, thank you very much again. And thanks for everybody for joining.